This podcast is sponsored by Murgatroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgatroyd.com/podcasts.
Welcome to the third season of Murgatroyd's Innovation Talks podcasts. We're delighted you've joined us. If you have any questions, please get in touch by email at innovation.talks@murgatroyd.com or via @Murgatroyd on Twitter. Don't forget to subscribe to make sure you don't miss any future episodes. So let's go straight into today's podcast.
Hi, I'm Steven Suèr and I'm a Director of Patents at Murgatroyd in Aberdeen. I'm delighted to be joined here by Jamie Allan, and today we are talking on the subject of how to protect your IP during the conference season. So Jamie, could you give me a little bit of background on why this is a relevant subject to us?
Okay, well, hi Stephen, and nice to be here. As the conference season is about to start, we just thought it would be useful to kind of go through some of these simple steps that you can take and things that you want to think about when you're going to a conference. And the number one issue is probably making sure that you have not disclosed any technology that you're thinking about protecting but have not done anything about protecting that yet. As you know, if you disclose new technology without filing a patent application, then obviously most people would understand that your rights to protect that technology are severely eroded and usually completely lost. So the main thing that you need to do when you're organising your conference trip is to ensure that you've thought about which products you're going to protect and which you're not going to protect. And that's a normal situation for most people. They will have products that they're never going to be protecting with any IP. And they'll have some products, maybe 1 out of 10 or 2 out of 10, where they're new products, they've not been disclosed before, they're commercially useful, and there may be some prospect of getting some patent protection or other form of protection for this. So crucial thing is, before you go to the show, before you publish your inventions, make sure you have filed your patent application. That's probably the most crucial thing, because once you go to the show and put your product on your stand, then your rights to obtain patent protection for that are going to be lost. Whereas if you'd filed the morning of the show, you'd still be able to protect that.
I know that certainly both of us have experienced this issue, and this can be quite problematic. And I know I've certainly been on the phone the night before a conference trying to work out what is being displayed and what isn't being displayed. And I know that certainly some of the times the issue is at things like conferences, the relevant people on the stand are salespeople rather than the technical people. And the salespeople, their job is to sell the product. So they are really out there to make sure that as much information of whatever it is that's being displayed is out there as possible, whereas we are dealing with the technical people. So how do you deal with making sure that the technical people and the salespeople on the stands actually know what it is that is protected?
I think you've got to make that decision well in advance of the conference and make sure that everyone who's on your conference team knows what bits of technology are being protected by patent application. Once you've done that, once you've filed your patent applications, you could choose to put those new products that have been protected on the stand. You might choose to keep them secret for a bit longer, and there are advantages in doing that. But most people, they want to get their products on the stand as fast as possible and out to the public. And as long as you have filed your patent application before the show, then that's fine.
Have you ever had to advise clients to withdraw products on the stand?
Well, no. I think once you've put it on the stand, even if someone hasn't looked at it, it's available to the public. So I think there probably wouldn't be much point in withdrawing the product from the stand in that situation.
I was thinking more in the sense of certainly I've had the experience where, as I say, we're on the phone the night before, and particularly to the US, where actually the technical people didn't know what was on the stand. And so the technical people had to get in contact with the salespeople. The salespeople then actually emailed us with all the information that was going on the stand. And at that point, we realised actually certain products had to be withdrawn,
Right.
because they weren't protected, or they weren't protected sufficiently. Because often, whilst you may have filed a patent application to, say, a first embodiment of a product, what they're actually showing is a further development of that product.
Yeah, right.
And in this case, that was the situation. And so we said, well, you can't actually really show that additional material, that additional embodiment, because you are likely then not to be able to get any protection for that per se.
That's a difficult situation. And in that situation, if you had gone ahead and disclosed the modification, then you'd have lost the rights to protect the modification, even though you would still have the patent application for the basic product. And that might turn out to be really important. In 5 years' time, that modification might be the major selling point. So that's absolutely right. It's really important to do that. It's very difficult to communicate that to the sales team from the technical team's point of view. Another thing that you need to worry about, I think, or at least be aware of when you're going to shows, is your competitors are going to be exhibiting products that may well infringe your IP rights. And it's quite common in our experience here in Aberdeen that local conferences, you'll see other people infringing your IP. And one of the things that we looked at in this blog was to flesh out a couple of bullet points that you could possibly take on board when you're going to shows. So the first one is identify your main competitors, and most people would know who their main competitors are, and you want to make sure where their stands are and have a look at them on the first day, because it's usually the stands are going to be set up and dressed the night before, and you're going to have the opportunity to go around and look at the stands, see if those competing products are there. It can be really important also to make sure that if there is infringement going on, you take steps on the first day to address that. And even when the products are on the stand, we've had quite a few examples where we've been notified by the client, at 10 o'clock in the morning of the first day that there's an infringing product on a stand, and we've been able the same day to do an infringement opinion and issue a letter requiring the infringer to stop and hand over the product that's infringing and deliver that onto the stand within even a couple of hours. I wouldn't want to do that every week or every month even, but that has been possible in several shows that we've been to. So it's something that you need to be thinking about, and just because the competitor's product is on the stand, it doesn't mean that everything is lost, and it's been quite successful in the past, our approaches to that.
So a lot of what we can do is quite proactive rather than reactive.
Sure.
So, for example, before a major conference coming up, I know that something we have done is write to our major clients to say it's coming up to conference season, essentially giving them trying to do a quick mini IP audit, really, to establish what they have, whether what they're showing is covered by what they have, and what to do if it isn't. And I think you and I have both been involved in circumstances where they really are committed to showing something because they've got the floor space and the stand, and it's expensive to exhibit. They really want to show something, so they need it protected. And so, there is that option. Okay, we know we have to do something here, so let's file a patent application. And that can be done in certain circumstances. It's not ideal, but within a couple of days or even a day, if it has to be done.
Yep.
If it has to be done, it has to be done. So obviously, the more proactive you are, the more you prepare for these things, the less likely it is that you're going to fall into that trap of having to do things urgently, which is never a great thing. But certainly also being proactive about looking for the potential infringers is another aspect. You can look at, you get the guide before the show, which shows you competitors. So you can do a lot of legwork beforehand to make the whole process much more efficient when you're there.
Sure. Another thing that you probably want to think about is if you do see someone who you think is infringing your IP, you probably want to be careful about how you approach them, because many people fall foul of legal provisions in the UK in particular relating to groundless threats of intellectual property infringement. And this can happen where you accuse somebody of infringing your patent. if you're not careful how you do that, then the infringer can actually take action against you for issuing groundless threats. And although you might go on to demonstrate that the infringer was infringing and is liable for that infringement, it can be a hassle for you and it can take the initiative away from you. So it's important to be aware that how you approach that infringer can be really important and can either leave them in a strong or a weak position against you. So that's probably one of the other things that we talk to our clients about in these pre-show audits, making sure they're aware of what not to do and how to approach somebody. And our recommendation is probably that that's done by a patent attorney or other legal advisor.
Yeah, there's certainly an element of being IP savvy before you turn up to these conferences. Well, thank you, Jamie, for sharing your experience with us. It's been lovely talking to you. Until next time.
Thanks, Stephen.
Thanks for your time today. We hope you found today's podcast valuable. And don't forget to subscribe to make sure you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgatroyd.com.